Good morning, everyone. It's my pleasure to welcome you here to the panel, Making Sense of the Right to Data Portability. The panel is actually part of a broader 4-year research project funded by the University of Leuven, who's also funding this specific panel on data portability. So I'm also incredibly thrilled to present you this stellar panel representing 4 different perspectives on the right to data portability, and one moderator who will no doubt instigate a very lively discussion and help us make sense of the right to data portability. No pressure. First of all, let me introduce Lillian Mitrou. Yes, thank you. Lillian served as chair of DAPIX during the Greek presidency of the Council of Europe and is an associate professor at the University of Aegean in Greece. So she will talk about her experiences in the legislative process on the right to data portability. And then secondly, McIntyre, here in the middle, will give us a user's, or dare I say, consumer's perspective on the right to data portability. TJ is the chair of Digital Rights Ireland and a lecturer in law at University College Dublin. And then thirdly is Kaunistola. He's the EMEA Director for IP Standards and Interoperability at Microsoft. And so Eza will give us a business perspective on data portability. And then fourthly, Peter Swire, all the way at the right side, will elaborate on how data portability brings to the front the complex interaction between data protection and competition law. So Peter is, among many other things, one professor of law and ethics at Georgia Tech and a senior counsel with Alston and Bird. And then finally, we have the eclectic Lillian Edwards as our moderator. She's a professor of internet law, to be interpreted in its broadest meaning, at the University of Strathclyde in Glasgow. So before I give the floor to our panelists, the panel is divided in 2 main parts. First of all, we'll briefly hear short presentations by each of the panelists, and then we'll dive into 1 or 2 specific case studies that will hopefully bring to the front some key issues. And one last thing, we are being recorded, so later, if you decide to intervene, be aware that this might be put online forever. So with this, I'll pass the floor to Lillian.
Does somebody want to give me the little clicker thing? Do I need to use this?
I think first we'll hear from
this is another.
Oh, I'm so sorry.
Zef, it's another.
Yes.
It's quite complicated here with this and this. Okay, I'll try to do my best, especially trying to present in brief the rationale and the spirit of discussions in the Council, in Parliament, and in the trialogues. Although I was not participated to the trialogues, and the outcome of this discussion.
So.
Yes. Yes. What was the rationale of this new right? The main goal of the new rights, as proposed by the European Commission, was to ensure that users stay in control of their personal data in the online environment. From the very beginning, data portability was addressed from the perspective of the data subject. However, I must state that the dimension, the significance of competition was present during the discussion, and the importance of portability on those markets which, I quote, built on users uploading their personal data or their personal content, as presented by Commissioner Almunia in 2012, was always present as in the discussion. We are talking about a new right, a separate right. According to the approach of the European Commission wanted the new right to ensure that users stay in control. Sorry. I have sorry. I do have my problems here. For European Parliament, it was essentially regarded, data portability was essentially regarded as an extension of individual rights of subject access. That's why, in the amendment presented by the Parliament, the right to data portability was merged with the right of access in Article 15 2A. The position of the Council was principally that this right, while being in the prolongation of access of individual to her personal data, aimed at reinforcing the control of individuals on their personal data. Whilst discussions have shown that there was support among the Council for introducing a right to data portability, some delegations have expressed concerns on issues such as the perceived risks for companies' competitive positions, the administrative burden, which may be caused by such right or the scope of concept of automated processing system. Some delegations have also pointed the relationship of the proposed right to portability with competition and intellectual property law. For example, UK, while it supported the concept of data portability in principle, considered it not within the scope of data protection, but in consumer or competition law. Several other delegations also wondered whether it was not rather a rule of competition law or intellectual property law, or how it related to these fields. Such delegations were the Denmark, the German, the French, the Irish delegation, etc. German, UK, and other delegations pointed also to the risks for the competitive position of companies if they were to be obliged to apply this rule without any exemption, and referred to serious issues about intellectual property. German and French referred also to services such as health services, where the exercise of the right to data portability could endanger ongoing research or the continuity of the service. Reference was also made to an increased risk of fraud, as it may be used to fraudulently obtain the data of innocent data subjects. That was the concern mainly of UK, I must say. And we had a lot of other concerns which have focused on these main issues. The European Commission, concerning to the scope and the object of data portability right, mainly aimed to target social networks. In the impact assessment report, the personal data, it was written that the personal data that may be transferred under the right to data portability was described as photos, list of friends, contact information, etc. And there was an explicit reference in the recital 55, the main recital concerning data portability, a specific reference to social network. Not only, or there was also the expression to another one, etc. The European Parliament has another idea about this, and according to the amendment, the new right will apply to all controllers that process personal data by electronic means, including, that was the interpretation, cloud computing and web services, not only social networks. This reference to automated means may limit the right to data portability to internet-related services. And I must say that the applicability to cases of offline data processing has been from the very beginning out of the discussion, because it was related mainly to the right of access. The data subjects, according to the new right embedded in Article 18, will have the right to receive data, provided that the controller, that they have provided the controller in a structured, commonly used, machine-readable, and I must point your attention to the fact that in the recital there's also a reference to the word interoperable, which does not appear in the text, but it may cause a lot of discussion and interpretation problems. And all these distinct formatting requirements must be satisfied in order to the data subjects to realize their right to data portability. I must say from my experience that there was a long discussion about what is the meaning of machine readable and structure, etc. And I'm really afraid that this discussion will be continue to take place during the phase of interpretation and implementation of this right. And I'm afraid that because of the uncertainty about the interpretation of these key terms, the exact scope of application is still unclear. The precondition for the rights to get a copy of the data to be applicable was that the personal data is processed by electronic means. In the amended text, the European Parliament has dropped the additional prerequisite that the data must be processed in a structured and commonly used format, and this way it was, he has widened the scope of the provision. In the outcome of the interinstitutional negotiations, the right of the trilogues, the right to data portability is subject to the condition that processing is carried out by automated means. Of course, there was some restrictions of this because the data has to be provided by the data subject to the controller and not produced by the controller. And I must say that there was discussion in DAPIX on the technical level if we had to add also the perspective of data being collected and processed by the controller but not given to him or her by the data subject. Only when processing is based on consent and contract, and in this case we had the exclusion of public sector. Public sector was excluded during the discussions on a technical level and then on DAPIX also. We had a reference during the Greek presidency, as fast as I can remember, a reference in recital 55, and this reference to recital 55 to the exclusion of public sector from the applicability of the right to data portability was also adopted in the general approach in June 2015. And it was, I think it was a wise idea because due to the nature of the right that should be, I forgot to change this. This will be exercised, it will not be exercised against controllers processing data in the exercise of their public duties. I must say that the reference in text is adopting the functional criterion of what is meant with public sector, not the organizational. And finally, I think it's more clear now, this restriction is adopted and embedded in the text of the regulation in Article 18. I would like to stress your attention also to the provision concerning the rights of the others. In the initial text proposed by the Commission, there was a reference to the right to export other information. This has caused a lot of discussion because it may conflict with intellectual property and other rights of the individuals. Because of the concerns that I have mentioned already, the Greek presidency 2 years ago has decided and proposed to adopt a paragraph which was related explicitly to the intellectual property. It was without prejudice to intellectual property rights, etc., which was also included in general approach. In the final text, we have a reference to rights and freedoms of the others, a very general reference. Intellectual property is not even mentioned in recital, and I think, and as far as I know, the focus is on the rights of other data subjects in accordance with the regulation. This is also written in the provision. And just a few remarks about the last decision. that data subjects have also the right to obtain and the right to transmit to another controller. They have the right to transmit those data without hindrance. And we'll have to discuss a lot about what is meant with without hindrance. I'm not very sure about the legal merit of this expression, but it was primarily, the primary aim was to prevent a first party from technically blocking the transfer to a second party, which is more a competition issue, not exactly a data protection issue. Of course, the initial proposal was that the European Commission should have the power to specify technical standards, modalities, and procedures for the transmission from the first controller to another one. This idea was not welcome by the Council, by many member states, and there's no power more for the European Commission to specify standards. And we have, in the general approach, it was referred that there will be no obligation for the controllers to adopt or maintain data processing systems that are technically compatible in order to facilitate the transfer from one controller to another. And in the final text, it was adopted, the proposal of the amendment of the Parliament, that this transfer from controller to controller without any act of the data subject, only if technically feasible. This could be regarded as a wise compromise, but and data controllers should be encouraged to develop interoperable formats that enable data portability, but this kind of wishful thinking, I might say, and I'm not sure if it will work in the implementation, in the praxis. That's all.
Thank you. That's really, really informative. Okay. Can we move on to TJ, who's going to talk about the kind of user-consumer perspective?
Well, I think, can you hear me, folks? I think Lillian's being a bit mischievous and talking about the user-consumer perspective, because I think I'd like to talk a little bit more broadly about the citizen perspective without reducing people to their commercial dimension. And in particular, I have to say that with all due respect to those involved in the drafting of the regulation on this topic, I didn't really know much about data portability before reading it, and I'm not sure I know an awful lot more about it after reading it. A lot of the points that I have concerns about have already been flagged by Lillian as issues that came up during drafting, and I think that perhaps as usual in a EU law context, there's a tendency to avoid certain points by stuffing them into the recitals or leaving creative ambiguity in place for them to be determined at a later stage. But one issue that strikes me in particular is almost a definitional one. Are we going to say this is a new right, or is it an extension of an existing right? A lot of the discussion has been of this as a new right. I see it in some ways much more as an outgrowth of the existing subject access right, which means we have to look at how the existing subject access right performs. So in Ireland and the UK, for example, we've had particular problems with abuse of subject access, where people have been forced by employers, by insurance companies, to make subject access requests, looking for things like criminal record backgrounds, looking for things like medical histories, with a view to the insurance companies, the potential employer, getting all of this information, to the point where this type of forced subject access had to be criminalised in both Ireland and the UK recently in the case of employers. And as I understand it, the UK Information Commissioner's Office is at the moment taking enforcement action against insurance companies for demanding this type of access. Now, it strikes me that if we have a right of data portability, we have in many ways the same problems of what is in effect a type of forced subject access. We've seen this recently with Airbnb. Anybody here staying in an Airbnb apartment? Hands up. A few hands are going up. Did you notice that when Airbnb asks you if you want to verify yourself as a user, they ask for access to your Google Drive metadata to prove that this isn't a recently created account? It's an anti-fraud measure. But this is, in effect, a type of data portability taking place at the moment. And it's obviously a very invasive type of data portability, because while the intention might be an anti-fraud one, nevertheless, the extent to the information they get by getting access to all the metadata about your Google Drive contents is very invasive. Likewise, you can think about other examples of situations where, to use a service effectively, you might be compelled to make use of a data portability feature. We can think about a service which says you may only sign up to us if you transfer your data from your prior service, or perhaps, as in the case of Airbnb, you only get the premium experience if you transfer some of that data to allow us to carry over the reputation or the background or the anti-fraud tracking or whatever it is that they aim for. That to me is a real concern. It was a concern in Parliament as well, because Parliament included in the recitals a provision that providers of information society services should not make the transfer of those data mandatory for the provision of their services. And somehow that got lost in the final text. I don't know why. But I think that is a real risk that we are going to see. The exact analogue, if you like, of the forced subject access request. The second area where I have particular concern is around the privacy rights of third parties. Now, there is a problem here, I think again an ambiguity in the text as regards what data is going to be the subject of the transfer. So the text at the moment refers to the transfer of data provided by that data subject, which if taken literally would mean you could export your outgoing emails but not your incoming emails. And I don't think anybody sees that as a realistic prospect. But there are privacy concerns associated with the transfer of data which originates with a third party or which incorporates a third party. So I might be happy sending my photographs to X while he's on a particular webmail service. I might not be happy with X transferring that data to, for example, Facebook, if I think it's now going to be the subject of, for example, automated facial scanning or the creation of shadow profiles or the various other complaints which Max Schremm in particular has made in previous years. Now, the directive, as mentioned, the regulation, as mentioned, does acknowledge these concerns. It refers to transfers taking place having regard to not adversely affecting the rights and freedoms of others. Again, how is that actually going to be operationalized? I don't really see how this particular problem is going to be resolved. Now, you might say to me that this is an artificial problem. It's not a real problem because these other abuses would be abuses in any event. So maybe you might say the concern should be about the later handling of the data by the third service to which it is transferred, not the handing over of the data to the data subject. But I think in practice those concerns are going to be inseparable, particularly because in many cases we might be talking about data being transferred from service X, which is based in the EU or has an EU presence, to the user, who may then transfer it onto service Y, which may either not have an EU presence explicitly or may not in fact be abiding by EU laws. You might say in that case, well, we should be regulating the behavior of the individual user, the individual citizen in that case. In practice, I don't think that's necessarily going to be a realistic response, particularly if this is going to be a more wide-scale problem. A final point. One exclusion that struck me as unusual was the exclusion from the exercise of public duties. Because I think there is a mistaken belief here that data portability is purely a competition law issue, that it doesn't arise in a public law context because you don't get to choose which government you want to deal with. But of course, it's about more than a competition law issue. It's about the possibility for the individual to monitor how their information is being used. So data portability can be very useful here. If I can get a structured set of my data from the Irish Revenue, I may be able to hand it over to my tax advisor who can tell me in a more efficient manner, am I paying the right amount of tax? Likewise, if I can get structured copies of my health data from the Irish Health Service, I might be able to learn from that even if I don't get the luxury of choosing an alternative health provider. So an unusual exclusion in some regards, I think, one where from a citizen perspective it might be desirable to see it extended more widely at national level. And I think I've run a little bit over time there, so my apologies.
Very, very interesting. Sorry, I wasn't stopping you because I was scribbling notes. So next we're going to have Isa Kaunistola from Microsoft, who's going to give us an industry perspective. Probably horribly mangled your name, sorry.
No worries, it was quite right. Good morning, everybody. So given my background, I will be sort of discussing this from standards point of view, because the issue is rather complex in cloud computing altogether. And whilst talking about portability, we should have also in our back mind the interoperability issues. And then, of course, there are sort of cross-cutting issues here which relate to sort of security and privacy, as we've been discussing, and switching costs, which, of course, are a matter for both the consumer and the business perspective. I think it probably is good to say a couple of words first about the sort of interaction between interoperability and portability. So in interoperability, you talk about the ability of diverse systems to communicate, or systems or components to communicate with one another. In portability, it is more of ability to run sort of components or systems in multiple hardware or software environments. So that is a basic difference there. A portable component is not necessarily an interoperable one. So that is like the starting point. Then if one is looking at this question from a standardization point of view, then obviously there is at the moment an ISO standard 19941 being discussed, and Microsoft is one of those companies who are heavily involved in this process. And for the purposes of standardizing the portability, there are sort of two aspects which are important. One is data portability model, and the other one is application portability model. And this standard I mentioned, 19941 Information Technology Cloud Computing Interoperability and Portability Standard, defines four facets for data portability within the context of cloud computing, and through them the data portability will become effective. And the link to interoperability again is that this model is sort of derived from the interoperability model. And there, of course, are existing standards which are sort of in use, and they provide for common syntax for data portability. And there are, as I said, four factors: syntactic portability, which means that the receiving data in a form is sort of defines the receiving data in a format that the receiver understands that. And in that case, the data will be structured according to the data model defined by the semantic facet. And in sort of more in layman terms, this, for instance, means if you think about sort of word processing standards, that this syntax is based on XML, for instance, which means that you can read sort of different sort of documents, even if the basic standard is different. And then the semantic portability, in turn, is defined as a mutual understanding of the data model with the domain. And then we have, as a third part, the pragmatic portability, and that is the degree to which there is an understanding of the intended use of the exchanged data. And providing the intended use in the target system is similar to that of the source system, the data should be usable. and the context in which data is used will dictate its usefulness. And finally, we have the policy portability, which is sort of relates to sort of applicable law, organizational and policy frameworks. And then it's the concerns also regulation on data location, rights to access, use and sharing of data, and mutual responsibilities relating to security and privacy. But this is something which is outside of the scope of the standard at the moment. Secondly, the application portability model, which is sort of another part of this, what one can transfer, and it is about the ability to migrate an application from one cloud service to another cloud service, rather than just sort of data itself. And this is sort of comes with similar sort of facets, but I don't go into those details, because that is for eventually, for the purpose of this discussion, the data portability is a key scenario to look at. And because one could argue that the application portability is less value, and it's also obviously much more complex to come with. And in relation to the data portability, there are certain aspects how the standard will, of course, help. It is, in particular, that international data transfers need to transfer the data from one service to another, sometimes in different legal systems. And the data controller needs to be able to know the technical measure covered by each service and compare them to make sure the data transfer from one service to the other is suitable. And standard will provide a framework for analyzing and comparing each of those services, understanding the differences and focusing on each service's specific features. More specifically, when data leaves one service to another, the data controller will want to make sure that the data is not retained more than necessary after the contract has been terminated and it is securely deleted. And again, the standard can improve transparency of each service capabilities in that aspect. And there is already an existing standard for in 27018, which has data deletion controls, sort of stipulating how that will be done. And then, of course, the other consideration is the format in which one gets the data, and whether it will be then understood by the other service to which it is transferred. And of course, then the standardized formats will help to ensure that to happen in that sense, as appropriate. And so based on these concepts, one could say that the cloud computing is such a natural evolutionary next step forward that embraces the basic concepts of interoperability, data and application portability. And in order to try to sort of address and look at this very complex, or the complexity in manageable way, one needs to have these sort of structures.
I think we should probably wind
Yes.
up there, yes?
So that is sort of how we have the standardization there to help to achieve this.
Okay, thanks very much for that. Okay, so the last brief presentation on the panel is from Peter Swire, who needs no introduction, who's going to talk about it from the competition perspective.
Hi, everybody. Can you hear okay in back? Is the sound okay? Yeah? Okay, so somebody in the back nodded their head, thank you. So this is about data portability. Data portability is a very desirable concept for us as users. We want to have control over our data. We don't want to be frustrated when we're trying to get our things done in life.
I teach now at Georgia Tech, which is a computing and engineering institution, and pretty much all the software engineers I know have a strong instinct in favor of portability, interoperability. That's the default view in the technical community in many instances. I've also taught competition and antitrust law, and so I've been asked to speak on that part. And I have a question. How many people here have taken a course or studied antitrust or competition law before? So maybe a quarter of the people in the room. It's a very weird, strange way of thinking compared to data protection in my experience. They're very different concepts. And so I'm going to try to speak in a language that works for both sides of that linguistic divide. I think it's the case I was the first person to write on the intersection of privacy and competition law in 2007 when the Federal Trade Commission was trying to figure out Google DoubleClick merger. And I explained reasons why there might be privacy reasons within antitrust law not to allow certain mergers to go forward. I think I'm on this panel because in 2012, when the regulation, the draft regulation became public, Article 18 put forward the right to data portability, and with a colleague, I wrote a 45-page article on competition and data portability, and in some ways I'm going to try to explain the ideas from that today. But I have not been working on this day in and day out since that time, and so if I make some details wrong about the changes since 2012, my apologies on that. So first some observation on rights, and then I'll talk a little bit about competition law. Clearly, I think the right of portability comes out of the kind of ideas we had for right of access. Now, with the right of access under European law, as I understand it, the controller can engage with the data subject and say, do you want everything, or maybe you want this, or maybe we can do it in this format. And there's various restrictions on the obligations of the controller. It's not the practice under EU law that a user says, give me everything that mentions my name, and there's an immediate obligation to download every file. That's not the way the right has been. So when we think about portability, which is, at least as originally drafted, without hindrance and a broader thing, there was a possibility that this was a quite different expansion of the right of access in ways that were not clear at a technical level what it would mean. And just to give you one example of the scope of access, in our paper we were saying, well, maybe the things I uploaded to Facebook I get portability, but Facebook has a lot of different kinds of metadata that says what Peter did this day or that day and in connection with all the other users. Do I get all of that downloaded from Facebook? That would have data protection implications because I'm learning about everybody else I'm connected to, and it would have implications beyond traditional access because the details of the company's operations would be there in the metadata. So what the scope of portability is something that is different from data access, but is not self-defining. It was unclear originally what the scope would be. A second point about rights, fundamental rights in this area, in addition to right of access, is the right, which is in the directive and in the regulation, to data security. And even though the UK mentioned that and maybe not others, and that disqualifies it as a serious idea in the eyes of some people in Europe, if we have a download without hindrance, an immediate download without hindrance, there is a possibility of identity fraud. This is not hypothetical. So way back in 1999, the Federal Trade Commission in the United States commissioned a study with privacy advocates and technologists and companies how to figure out right of access together with data security. And so there's a 100-page report from that time that lays out the issues. The issues are similar today. So if you're going to have portability, I think it's important for the protection of people, of data subjects' rights to their own data to make sure the bad guys don't get the data. And in some ways that's very obvious, but it means any practical system here has to look at the fundamental right to data security about your data together with portability. So I just think that's, within European law, would be a sensible way to look at it as two rights that both should be upheld. Let me talk a little bit about competition law in this strange way. Competition law operates with language that seems strange in my experience to many privacy experts. So in competition law in Europe and antitrust law in the United States, the goal in the law is consumer welfare. It does use the word consumer, not citizen welfare. It uses consumer welfare. And so there's a lot of economist work to try to figure out what structure will lead to the highest efficiency, to the most consumer welfare. That's what the game is about. And in this way, data portability has some very attractive features. One attractive feature is maybe you get locked into a company and you don't like it anymore. And either they're a monopoly or there's just so hard to leave, and every day you feel frustrated because you're using this service you don't like anymore. And you have nowhere else to go, either because of technical lock-in or lack of competition. If we have a right to portability, this can answer the lock-in problem. Hooray, we have it, we're getting some nods in the back. Yes, that's what the idea is. It's very good. So I want to express within competition law, that's a clear possibility, and I think it's where the intuition for portability is strongest. Beyond that, there's another related point about interoperability in general as a wonderful thing. So there's books written and many people have written about how wonderful interoperability is because we can combine technical capabilities better, because we can move from one service to the next, because the second innovator can do it more easily if they're using a standard format. There's many wonderful things about interoperability. All of the standards for the internet are built around interoperability. So we cheer for interoperability, we cheer for avoiding lock-in. Within competition law, those are fabulous things about portability. Now I'm going to say the but part, right, which makes anybody then the bad guy in a discussion like this. It's not only these wonderful things in competition law, there's other aspects of competition law. So interoperability, the reasons to favor it are similar, not exact, but similar to the reasons to favor open source. And so many people in this room, if you have a choice of open source or proprietary, a free software approach will say, oh, we should support open source. But we observe in the marketplace, there is also proprietary software. And part of the reason is that the economists believe there will be more investment in new innovative products if people get paid for the product sometimes. And so there is not a strong legal rule in the competition area that says only open source. There's a rule that says many times proprietary software will actually lead to higher consumer welfare, and we encourage the investment and innovation that does this. Similarly, and this is not in a monopoly setup, but imagine now you're starting your new software company, and you want to get some money because you'd like to keep doing it, and you'd like to be able to get a cool service that people will use. At the beginning, the first day, many times you don't make it interoperable. Many times you try to make it sticky so people come into your service and spend many times using your service, and then your 3 best friends do apps that connect to your service, and the next 50 have ways that are part of your ecosystem. And there's elements of interoperability, but the investment comes because people think they're going to have a wonderful product that will eventually lead to money, that will pay for the software people to write the new software. And this is the competition law idea that generally people are able to invest and create their product in the way they wish, unless there's a reason not to. One reason is if they're a monopolist. So if they get to be very large, 50%, 30%, 80% of the market, then the competition law, depending on the jurisdiction, says, watch out. But the day you're in your garage, the competition law says, go have fun. Make a proprietary system, don't worry about interoperability. And competition law in the EU and the United States, the threshold for when that lock-in or monopoly happens is much, much higher under competition law, 80% kind of things, than most people's intuitions. So there's many times people in common speech will say somebody has a monopoly. When you look at competition law and you define the market in competition law terms, there's not a monopoly. Competition law does not put the restrictions on it. So and then one other thing from competition law. Let's say today there's a company with 90% market share. Tomorrow, they might not have that. So I'll talk about a hypothetical company that had an operating system market share of about 90% in Europe, let's say in 1998. And everyone knew that this company was never going to be stopped, and their monopoly power was so bad that it required massive intervention to stop the monopolist in operating system and in browsers from taking over Europe and the United States. There were antitrust actions against this hypothetical company called Microsoft. Today, people don't think Microsoft is the big monopolist that makes everything on the internet impossible. You have a different list of monopolists to worry about. And by the way, those monopolists are worried also. So for instance, I've read an article recently about Google, and Google has had a fabulous lead for search and search advertising on the desktop. They make their money because of all the clicks you do next to the searches on Google. On a mobile system, the clicks and the advertisements next to it are very different. And Google has been lagging on advertising revenue from the mobile market. If mobile becomes dominant, as most people think it will, the people at Google are saying, oh my God, we're going to be like Microsoft. We're going to get leapfrogged, and there's going to be a new round of winners in the mobile space, and it might not be us. I say this because even proof of a high market share today in competition law does not establish that it's the kind of monopoly that requires intervention for competition law reasons. And this leapfrog competition is something that's important in competition law that allows more activity by the companies before the law steps in for competition reasons. So I think those are the main points. I tried to say within competition law reasons to cheer for portability, reasons within competition law why competition law often would not step in as competition law. And I think maybe I'll stop there and we'll go to a discussion.
Please. Okay, we need the other slides. Thanks to all the interventions there. I certainly learned an awful lot.
Do you want the first case study?
Yes, please. Okay, so what we're going to do now is we're going to present a couple of case studies. Now, these were dreamt up by Jeff, who's done a huge amount of research for this panel. Can we go on to the next slide? Sorry. Because we hope that this may focus the discussion, because I'm sure that you've all got questions you want to ask after these interventions, but we thought a formal, a hard, concrete case study or two might really help. So what I'm going to do is go through these case studies, then ask the panel to comment on them, then we'll bring in the audience, okay? So, can we go back one? Where's your pictures?
Ah, okay. I want the pictures.
Yeah. I think people understand pictures. Okay, so we have two examples, and I personally, to be controversial, think one of them is a real issue where we need a market intervention, and one of them perhaps isn't. Okay, perhaps you can guess which. So here's the first example, which is something I think we're all familiar with, which is I spend my entire life going and looking for hotels on TripAdvisor and finding out if they are, you know, the second-ranked hotel in a particular city, which I can afford. So we're very used to these kind of ratings now on Amazon, on eBay, on TripAdvisor, on Yelp, and so forth and so on. The question is, and if we go on to the next slide, is do we need some kind of intervention here? Do we need a portability right to enable us to take that rating to another site? So in this example, we're talking about Amazon Marketplace. And as you can see, we've got the example of someone who's been selling used books on Amazon for a good long time. She's built up a very high user satisfaction rating. If you look at these as I do, you find that most people have got like 98%, 99% satisfaction. So you can query for a start if there is any real competitive aid there. But she wants to take it to another site, booksforsale.com, where she'll be charged a lower transaction fee, which is certainly a big issue for small users, small businesses trying to use these platforms. But she finds that she cannot effectively port her Amazon rating to booksforsale.com. And the argument made here is that this means that this inhibits the growth of a market of competition because it inhibits the growth of booksforsale.com. It doesn't attract a critical mass of buyers, therefore synergetically it doesn't attract a critical mass of sellers and so forth. So do we have a switching problem here? Do we have a need to move the reputation or the score? And perhaps most significantly, do we have a right or a means to move the underlying data that translated into that 98% or 99% satisfaction rate? And that for me, and this is just my own little frolic, raises very much the issue of the underlying algorithm and the transparency of that, and whether we have any rights, either transparency or portability over that. Okay, if we go on to the next case study. Thanks. My beautiful assistant, next page. Sorry, I just haven't worked out how to use this one. Okay, so here's a second case study. Who's got a wearable here? I had for a bit, but all the water got in and it leaked. I swim. So, you know, half the people I know have got these. Maybe you don't know enough women of an older age. And people are wearing these wearables to swim, to walk, to sleep, to work, to breathe. And they're amassing enormous amounts of personal data, very sensitive data actually, about their health and their habits, their sleeping hours, etc., etc. Okay, we go on. Thanks. Oh, no. Cut into the chase just a little bit too much. Okay, so we have the example of a Microsoft band. Can I have one, please? I've never tried that. And finds it very useful for getting feedback about her workouts. So now this is the one giving it away that I think is a real issue. So although obviously the market has led to some partnerships, so that, for example, you can very easily download your Fitbit data to Facebook and so forth, not every company is in partnership with every other company. So the issue here is perhaps that it's difficult to import data from her Apple Watch into Microsoft's Health Vault. I have no idea if that's accurate. Perhaps we can get some technical advice on that. But she also has difficulty not just about interoperability or portability between two services, both offering similar functionality, but she has trouble getting the data out in a usable, easy and convenient format to give to various people. Now here we have some of TJ's concerns. So in this example, her insurer has asked for this data. In this example, she is keen on giving it. In many other examples, she would not be. Her employer also wants access to this data. Now notice rather cleverly in this case study, it's implied that she gets benefits from the employer, not merely the threat of breaking her employment contract and being sacked if she provides the data. So yeah, we have a kind of market-friendly case study here. And then finally, the one that I've actually known people who've encountered, she would like to take that data to give to her physio, to her physiotherapist, who presumably also has a Mac or something in which she can calculate ideal exertion or something like that. So the physiotherapist could really use that data for the benefit of Alice, but the physiotherapist, whether it's because she's not very technical or because the data actually is impossible to merge, cannot easily use it. And I think this shows some of the difficulties of making principled statements about this kind of right, because these are really, really different case studies, and I personally don't quite know how you would draft to differentiate between them. So, a little bit of skepticism creeping in there. We're going to go to comments from the panel, and I think the suggestion, does anyone want to make a burning response to any of these? That would be the correct way to do it, wouldn't it?
Just a remark.
Right. You were first on my list anyway, so that's great.
Just a remark. Because actually, I was wondering for your second case, sometimes I had the impression that data portability is here to solve all the problems of data protection.
Yes.
And I don't think that this is the case. Perhaps we have to narrow the scope of data portability. I'm not sure if it was the intention of the Commission when the Commission proposed this new right, in brackets, but I'm not very sure if data portability can solve all the problems, because especially in the second case, we have a lot of problems, data protection problems to face and to deal with.
Yeah, I'll bring in other people. I mean, my own response to that would be the case study's been constructed to say that there aren't other problems because she appears to be giving a valid consent. If she was giving a forced consent, in which there was a significant imbalance of power, then other parts of it...
It is a forced consent.
Is it a forced consent? Well, what do the other panelists think? What do you think, TJ?
I think there is a significant problem here. Whenever you talk about employer or insurer access to this data, it's not necessarily a data protection problem in a portability sense. It's the same problem you see with insurance companies giving you discounts if you put a tracker in your car. The problem is an adverse selection problem in economic terms. The only people who aren't going to put these things in are the few privacy geeks, that's us in this room, and the people who are bad drivers. So eventually you end up in a situation where your premiums get very expensive indeed if you don't hand over the health data, if you don't install the tracking device in your car. And maybe just to modify that slightly as well, I think one of the problems with the health tracking scenario is that it frames a competition law problem as a data protection problem when very often it's not going to be. So increasingly consumers are wary about putting health data in the cloud. Increasingly you're seeing business models like Apple where you have the option of storing the data solely on your own device. And in a scenario like that, I think it would normally be fair to say that Apple is not the data controller in that situation. So to the extent that you've got a competition law desire for interoperability, to let people move from their Apple Watch to their Fitbit to their whatever, you don't have the same data protection principle backing it up. Again, possibly suggesting we're trying to solve a market competition law problem by trying to hit that particular nail with the data protection hammer, not because it's the best tool, but because it's the only tool we have right now.
Can I just throw in as an interesting thing that there is already a circumvention arms war going on with this? So I saw an example of where an insurer was in fact demanding health data from a data subject, and there is an app which can fake your health data so that you appear to be this healthy person who's going out and running every day, but actually you're sitting in the bath reading a comic, you know? And I think that's also the future. We should never underestimate the ability of geeks to start avoiding technical problems. Okay, are we bringing in the audience?
Can I? Oh,
Peter.
I was going to.
Peter, right.
Is this on still? Yeah, it is. Well, one thing is, I don't know the European law. In the United States, if it's a government and you lie to it, that's a criminal act in a lot of settings. So whether you can send health data to a federal provider and lie about it, I don't know the European law of whether that's permitted or not. Is it a legal problem to lie to the government in Europe?
Of course. Everywhere.
Well, so there could be circumvention, but then you go to jail, so that's not a perfect solution. So but I wanted to just, maybe on the Amazon one, yeah. In the Amazon one, if we go back to it, and by the way, I hope the seller can find ways to link to the Amazon page, and the outside person can check their Amazon rating. But I wanted to just make a quick point about how difficult it might be to get that result under antitrust law. So let's say Amazon made it hard for you to show your Amazon ratings to people unless they were doing it inside Amazon, made it hard to export it. That can seem like just the kind of lock-in that people are worried about. But under antitrust law, you could only go against Amazon if they were doing what was called exclusionary acts, if they were doing a legal action that was going to violate the antitrust law because it was so bad it gets under exclusionary act. And exclusionary acts are not per se unlawful. They're what's called rule of reason. So you'd have to look at a lot of facts. And under EU law, which we analyze in our law review article, in many of those instances, it would be hard to win against the Amazon situations under competition law. So unless they had very clear market power, unless there really were not alternatives, unless you could prove in the fairly small categories of exclusionary act that it fit, it would be hard for the competition authority to step in under competition law. That may lead back to TJ's point, which is this is a way to use data protection regulation to get at things we care about. The point I'm making is for antitrust lawyers, it might be harder to win than you'd expect.
Yeah. If I can bring in our technical expert here maybe, because when I looked at the Amazon example, it was the one I thought was actually in some ways trivial and didn't require some kind of market intervention, which this really is. Because if you do drill down to an Amazon 98% satisfaction rate, you do indeed find that all the reviews are there on what appears to be an open, unprotected page on Amazon. So as Peter was saying, you don't even have to go as far as getting into an API. You can just do a link to the URL of that page. How Amazon would try to block that seems very difficult to me, given that you want the rest of the public to be able to look so that they have faith and trust and confidence in these ratings. So are there technical ways this could be blocked? Do you think this is a problem that's going to need legislative intervention?
Well, first of all, I need to make a disclaimer. I'm not a technical expert.
You're
Sorry,
an industry representative.
I'm a policy person as such. But I do think in the practical, very practical solution indeed is to have a link. And that's my own experience at least, that when you're looking at sort of some service providers, they might have sort of a link to all sort of ratings, and that where you get the benefit. And usually the pragmatic approach in this sort of situation is the best. But obviously, if the point I was making earlier about the standards is that if the market gets mature enough, then of course there will be sort of a need by the consumers and an appetite by the industry to sort of come up with consortia and make a standard. So that these sort of a portable, there will be portability solutions which are simple and simple to offer to consumers, like alias in this particular case. So that's one solution. But still, I think the first one is probably the better one
Yeah.
at this stage of the development.
I mean, as an amateur in this completely, I'm aware of the fact that there are these data formats like XML or comma separated or whatever, and many of them seem to be able to be stuck into each other with relatively little loss of semantics. Is this actually a big problem? Is this a problem that's going to hold up the implementation of the right, do you think?
Well, indeed, that's the XML is a good example, and on that front, you have already that happening.
Yeah, yeah. So we have a question from the audience, yeah? Would you like to say your name and where you're from, perhaps?
Hi, I'm Sharon Nas from the Dutch Data Protection Authority. I was just wondering, this Amazon example, the user has not provided ratings about herself. So I don't think she would be able, under the currently agreed compromise text, to get any access at all. And just to go a little bit against what Peter Swire said, I actually think the right of access is much broader and does allow you to get an electronic dump of everything about you, including metadata about you, like these ratings. And opposed to that very broad right, I am personally quite a bit disappointed about the very narrow limits of data portability.
That's a great question. Shall we take a few questions and then pass them back to the right? So, Ian, do you want to say who you are?
Yeah, Ian Brown from Oxford University. Just a quick follow-on to the point about standards and the market incentives for companies to develop standards. Of course, in many market structures, particularly of the kind that we see in many information markets, where you have a very dominant individual company, the different parties have different incentives to participate in standards making. Some of them have very strong disincentives to do that. So I don't think we can just, obviously we can't blindly leave it to the market.
We've got someone over there, I think, yeah? Is there a microphone near that person, or do you just want to shout? Hang on, the mic's coming. We probably need it for the recording. You can just say your name and where you're from.
Simon Hania, I'm from TomTom, a company that also builds these kinds of wearables. Now suppose Alice would be able to take her data and put it elsewhere. Wouldn't it be then that she starts to decide purpose and means of what gets done with her data? So isn't she inherently becoming the controller of her own data? Isn't this about democratizing controllership? And what kind of worms does that open? That's the question I would have to the panel.
All right. Shall we pass these three to the panel?
Well, can I address two of those points? The first, as regards Alice, I think there's a real problem here, which is that we're trying to kludge a solution. So she's trying to use data protection as a reputation management tool, and we're a little bit unclear about whom the Amazon reputation is being sold to. In my Airbnb example earlier on, the fact that the Google Drive metadata was being used to prove reputation to Airbnb. Here the desire appears to be to use this to prove reputation to the end user. But of course the end user isn't the one to whom the data is being transferred. It's being transferred to booksforsale.com. So in effect, you can only get around that by taking all of the ratings, copying them across, and then Books for Sale validating that these are the ratings we received from Amazon, displaying them on the Books for Sale page. But of course, at that point, you're engaged in a further data protection problem, which is that you're taking all the ratings and user details associated with those ratings from site A and putting them onto site B without the consent of the people who gave those reviews, which I don't see as being feasible. The second problem, and it was highlighted by the speaker from the Dutch Data Protection Authority, whose name I didn't catch, my apologies, which is that she views the access right as being much wider than the interoperability access right. I think that's a very important point, because if that's correct, and I believe she's correct in saying that, you are going to end up with two parallel routes to access data. You will have a plain vanilla access right, which gets you everything in a clunky format, and you will have your higher interoperability right, which gets you a narrower set of data. So you are going, in effect, to have to make two sets of data access to get the sum total of your data. This isn't new. You see it in public law already, where if you want all your data, you're probably going to have to make a Data Protection Act request and also a Freedom of Information Act request in parallel. And those of us who are practitioners have often had to go down that particular road. But it does seem to be a very clunky and, I think, unanticipated outcome of the regulation.
I think that's a really good point. Can I just add in, and I will respect what Shura says on this, but my belief is that there have actually been cases, I think there was one in Germany, wasn't there, and maybe one in France, that have declared that ratings, there have been a number of ratings cases, that ratings are the personal data relating to the data subject. There was a Rate My Teacher case, no?
In Germany there wasn't.
They are definitely personal data. That's not the point. The point is that the new GDPR data operability right would not apply to ratings provided by other people.
No, absolutely, absolutely, yeah. Okay, I misunderstood you.
So does that mean then that you can get you can get your own personal data that you've provided in a lovely structured XML, and other people's ratings are going to be this grainy photocopy of a PDF?
Yeah. In which case, you might as well just do the link to the original page, and you'll actually be giving more data.
The GDPR actually has improved on the access rights, because they say in a common electronic format, so no more grainy
PDF. Where are we at? What are final reactions? Yeah, do we have other reactions either from the panel or the
Concerning
audience?
this question, which is very important, about narrowing the scope of, I would like just to say that the initial proposal reflected actually what was also the source of the Data Protection Directive. It was this bipolarism, let's say, protection of rights and creating the condition for a competitive market in the internal market. And this is also reflected also in the data portability case, because it was an attempt to enhance the position of the data subject, but it was also not only in the data protection perspective, but also in the consumer perspective, and it was an attempt to protect the data subject as a consumer from user lock-in. And I'm afraid that this addition that the data controllers should be encouraged to develop interoperable formats won't widen the scope of data portability. It makes it narrower than the right to access to data.
All right, let's take a last couple of questions. I've actually got one I want to ask myself, but I think we have that gentleman there, then someone else, then Ian again. Right, so let's get those questions in.
Once again, one question to those conflicting principles in data protection. I think TJ also mentioned it. You have the data subject has the right to receive the personal data concerning him and her, which he or she has provided to the controller. Does that mean that the controller has the obligation to store those data forever? Because there could be, the data subject could get the idea to use this right data. On the other hand, you have the storage limitation principle. So those principles are conflicting.
Interesting. Okay, we had another question up there. Is this too late to answer one of these myself? Oh, yeah. He's got one.
We're looking at a new range of services which are perhaps enhancing technologies for KIMS, information management. You'll see later today Digi.me at 4:45 for the major and Cruising Cloud, MyIndex being examples. The question for them, and we had a granting with them earlier, well, later last year, is whether they could actually benefit from the right
Okay, and final, last comment, then I'm going to say something. Is it work? This one.
Picking up on what Lillian...
Oh, maybe it's... Just shout.
Picking up on what Lillian was saying, and also TJ and Peter's points about, it goes much more broadly than just privacy concerns. On the avoiding lock-in side, something that Chris Marsden and I, sorry to plug our book, said on this issue was that you don't just want the ability to take, honestly, if you want social media competition, users don't just want the ability to download their own profile, they want to be able to share photos and message and so on across platforms. And I wonder, using your sort of taxonomy, emerging taxonomy, Peter and TJ, where would that kind of thing best fit? Is that completely alien to data protection despite the single market? Is that pure competition law? Is it consumer protection?
Okay, and I'm going to throw in a last couple of questions. My God, this one works. Which is there any evidence that consumers are going to use this remedy? I mean, subject access rights are already vastly underused, except by kind of journalists and investigators. If they aren't going to use it, is it in any way going to solve the competition problem which is this was devised to fix? Is it fair to put the remedy in the hands of the consumers who have the least power? Are there not other ways of doing it? And on the converse of it, on the point about incentives, is there any evidence that, as the UK fondly hopes with its My Data scheme, that this will generate a whole new competitive wave of industry, of information intermediaries who will do something clever with this data? So, responses.
Boy, I think. So, I'm not, there were series of questions. How to get social media competition? I don't have a magic answer on that. The lock-in effect can be greater when I need to find 100 or 500 or 1,000 people who are in the same place with me. And so first mover or lock-in is plausibly stronger when it's not my decision, but it's the decision of myself and 100 of my friends where to be. So that's a reason to be more concerned about lock-in when it's the connections with others. And then the antitrust folks or competition folks would then run around and say, well, can you come up with different products? How big is the lock-in? Does anybody use Twitter? They say all sorts of things. So I don't, but I think one of the big facts about this going forward is that people are not required to use the standard formats. And so anytime a company is starting to feel the heat from data portability, they can at least explore using non-standard formats. And so it might take more efforts than just this to really force companies to do it. Last thing I'd like to say is, there is not, when we did our research at least 2 years ago, there were not other data portability mandates that we found in other member states or countries. So when you're starting a whole new legal regime, it does make sense to be a little bit careful at first to see what works and what doesn't, and then learn from it and then come back for a second and third try. So this is a new legal regime. Mandates at the start before you've ever practiced it before can be a little worrisome. But I do think it's very attractive to find ways for users to have portability. Just having mandates very quickly is something to be a little cautious about.
Okay, maybe we should work our way along with last responses either to the questions or to the topic generally. So, Lillian?
Yes, just to clarify that Recital 55 clarifies that the right to data portability will not interfere with the right of the controller to keep data that are necessary for the performance of a contract. He's not obliged, the data controller, to keep data in order to satisfy the right to data portability if this is the common principle, that if the data are no more necessary for the purpose of processing, etc. And data portability interferes neither with the right of the data subjects to request the erasure of her data. I mean, it's another field. This. What else? I'm very skeptical about the added value, I must say, of data portability, especially due to the outcome of the trilogue, because it is explicitly written that the data controller is not obliged to process the data in a way that, I have here the nice, in a way that they are compatible with, interoperable with other controllers. And this is, the added value will be in relation to access rights. The added value will be that the idea from controller to controller, without hindrance, without, and this, with this condition that if sorry, I have to find that. Where technically feasible, allows to contravene this.
Which will probably turn out to be a get out of jail free card like it used to be with cookies, you know? Although they've tightened up on that. TJ?
I think this discussion has progressively moved further and further away from data protection and interoperability and towards something entirely different, which is essentially about identity management on the one hand and reputation management on the other hand. Identity management, how do you prove you are you? We have decentralized solutions. You have open authentication, OAuth, which died to death. You have increasingly identity management becoming centralized with services like Twitter, Google, Facebook, etc., offering a login into different platforms as well. That is a problem. Would it be nice to see a decentralized identity management system that solved some of these problems? It might be. It's been tried. It's largely failed to date. I'm not confident it's going to succeed anytime soon. But I don't think that's per se a data protection problem. Likewise, reputation management. Is this person trustworthy? Who is going to vouch for both your identity and also the manner in which you've behaved in the past? Again, this isn't necessarily something that presents a data protection problem because it's not necessarily something that has to be done in a centralized way. But as long as it is, I think we're faced with this essentially data protection kludge where we're now trying to use a data protection tool to verify our identity, verify our trustworthiness, verify our past transactions and feedback in a way which doesn't fit very neatly. And I think we might be better off thinking about that as a separate area of law rather than trying to stretch the principles here to the breaking point.
Well, I would go back to the sort of a higher levels of data portability in a sense that the market, of course, is already working on this in a sense that there are these pragmatic, practical solutions we were discussing earlier. That's probably the easiest. And the other thing is then that the standards are being formulated. So that will give some further sort of comfort for both the controller and the data subject side that this will actually work.
Okay. Shall I say a last thing?
Yeah, I more or less agree with TJ, actually. What this has really made me think is that I'd like to write something about the law of reputation management. And certainly when I looked at rating site cases, it was fascinating that in Europe you turn to data protection as the most easy tool to use, and in the US and to a lesser extent England, you turn to libel, which we haven't mentioned at all. And I think it is obvious that there is a gap in the legal system here, which is also being filled by search engine optimization, technical tools, FOI requests, whatever. And that's perhaps something we should have a panel on next year. And I'll just thank all the panelists for incredibly useful expertise, and perhaps we can give them a round of applause. And also for Jeff, who did a great deal of work on this panel.
And to Lillian, of course.